Announcements, none. Papers have been laid. Question.
Leader of the Opposition.
Mr. Speaker, my question is addressed to the Honourable Minister of Labour, Human Resource Development and Training, Minister of Commerce and Consumer Protection. Whether in regard to roll your own cigarette paper, which is used for smoking synthetic and other drugs, he will state if his ministry has, on 14th March 2022, authorized the importation of approximately 22 million items thereof, of street value of over 460 million rupees, and if so, indicate the reasons therefore.
Mr. Speaker, sir, in accordance with Consumer Protection Control of Imports Regulation 2017, presently import permits are issued in respect of restricted goods listed in the 4th schedule of the regulations. No import permits are issued in respect of prohibited goods, which are listed under the 3rd schedule of the same regulations. The item roll your own cigarette paper was in fact listed as a prohibited good prior to 2nd of June 2015 and was delisted following the introduction of the Consumer Protection Control of Imports Amendment Regulation 2015. The amendment was made on 2nd of June 2015 relates to a policy decision in the context of the elimination of non-tariff barriers and with a view to streamlining procedures and facilitating trade in Mauritius. However, this item was then relisted as a prohibited good pursuant to the coming into operation of the Consumer Protection Control of Imports Amendment number 66, Regulation 2015 on 17th of December 2015. Regarding the regulation proclaimed on 17th December 2015, as a result of concerns expressed subsequently, it was decided to relist roll your own cigarette papers under HS Code 48.13 and rolling machines other than rolling machines of industrial types used to manufacture cigarettes as prohibited items as from 17th December 2015 through the Consumer Protection Control of Imports Amendment 6, Regulation 2015, GN 242 of 2015. Moreover, it was decided that items ordered or imported prior to the coming into operation of the regulation would not be affected, taking into consideration commitments which had already been taken in the period during which these items were not prohibited by law, namely between 2nd of June 2015 and 17th of December 2015. Thus, the regulation dated 17th December 2015 came into operation with immediate effect, but was not applicable for consignment which had already been imported, nor for consignment which had been ordered prior to the date of coming into operation. Mr. Speaker, sir, I am informed that the director of ZP Mouse Company Limited, Mr. NKS, sent an email to the then Permanent Secretary of the Ministry of Industry, Commerce and Consumer Protection on 14th December 2015, inquiring about the procedure for the importation of roll your own cigarette papers from his South African supplier for an order placed 2 months back. Subsequently, on the 23rd of December 2015, the Ministry of Industry, Commerce and Consumer Protection sent an email to the company, informing same of the regulation in place, and also referring to a press communiqué on 21st December 2015. Actually, the communiqué informed the public that Consumer Protection Control of Imports Amendment 6, Regulation 2015, have been promulgated and are effective as from the 17th of December 2015. Consequently, importation of roll your own cigarette papers and rolling machines other than rolling machines of industrial types used to manufacture cigarettes are banned except for those ordered or imported before 17th December 2015. Mr. Speaker, sir, I am informed that on 30th of March 2016, my ministry received an email from Mr. NKS, Director of Zippy Mouse Limited, informing that one of the company's directors, Mr. AL, represented Zippy Mouse at Salon International Tobacco and Accessories, Inter Tabac 2015, where he met with one Mr. Alex Jokovic, Director of Clipasale Limited, and placed an order for 25,000 boxes of OCB tobacco rolling paper on 16th of September 2015. In the same email, the company requested the ministry to do the needful to have the consignment of rolling paper ordered declared by the Custom Department. The company in the said email attached the scanned version of a letter dated 30th March 2016 addressed to the Ministry of Industry, Commerce and Consumer Protection from Mr. Alex Jokovic, Managing Director of Winley Limited, Clipasale. The letter mentioned that a purchase order dated 16th of September 2015 for an order of 975 boxes rolling cigarette papers had been finalized and could not be cancelled. It further mentioned that the forecasted purchase order consisted of 25,000 units of OCB king size plus tips, and that delivery of 500 units and 1,000 units were due to start. The company also requested the ministry to issue a permanent delivery certificate to cover the remaining balance of the whole order. On 31st March 2016, my ministry informed the Director of Zippy Mouse Limited that it had no objection to the importation of the consignment for a first batch of 975 boxes of roll your own cigarette papers. As regard to the remaining orders, out of the forecasted 25,000 units, the company was requested to show proof that the remaining balance of 24,025 units was placed prior to coming into force of regulation GN 242 of 2015. The Custom Department was also put in copy of the letter and was requested to stand guided by Regulation 242 of 2015. Following the Ministry's request for proof of the remaining order of 25,025 boxes was placed prior to 17th of December 2015, the company on the 6th of April 2016 submitted a document certifying the purchase order dated 16th of September 2015 for the 25,000 boxes. Thereafter, my ministry, on the 12th of April 2016, requested the company to provide the following information: pro forma invoice, final invoice, bill of lading, receipt of payment made, document certified by supplier to show actual proof of order placed for 25,000 boxes, and any other relevant document certifying the said transaction. On the 10th of May 2016, Zippy Mouse Limited submitted all documents requested by the ministry except for the bill of lading. Consequently, on the 1st of August 2016, the then Ministry of Industry, Commerce and Consumer Protection gave its no objection to Zippy Mouths Limited for the importation of the remaining 24/7 and 25 boxes of roll your own cigarette papers. Thereafter, the company imported 2 consignments of roll your own cigarette papers, namely on the 12th of December 2016 and on the 4th of August 2017. On 18th of September 2017, concern was raised by officers of the Mauritius Revenue Authority on the possible abuse of the said regulation by ZP Mouths Limited. Consequently, from that date till 11th of March 2022, various correspondences were sent to the company. Meetings were held in presence of officers of the Customs Department of the MRA to sort out the issues. Mr. Speaker, sir, finally, on 11th March 2022, the company submitted a request for the ministry to allow it to import the remaining consignment of 24/7 and 25 boxes of roll your own cigarette papers as a one-off importation in order to resolve the matter, as the remaining order had already been paid for and would be for personal storage. On receipt of the documentary evidence requested by the ministry previously, a no objection letter was issued to the company on 14th of March 2022, subject to the following conditions being strictly adhered to. Firstly, the company had to produce documentary evidence to the MRA to the effect that the order of 25,000 boxes had been placed before 17th of December 2015. Secondly, the remaining 24,025 boxes of goods be imported in one consignment and the said goods not to be commercialized and not to be put on sale on the local market. Further to the no objection letter given to the company, the letter was also copied to the Director General of the Mauritius Revenue Authority and the Director of Customs Department. On 18th of March 2022, the MRA informed the Ministry that it would ensure that the conditions stated in the letter dated 14th of March 2022 would be adhered to, but will not take the responsibility should the good be commercialized and put on sale on the local market.
Okay, I understand that these goods now have been seized, and one, I think Mr. Jonathan Augustin, has been arrested, etc. Let me come to the letter of 14th of March 2022, which you refer to. Now, your ministry authorized the importation of 22 million papiers, which we know are used for synthetic drugs. And in the same letter, you put that, in fact, this is not to be sold in the local market. Did it occur to your ministry at all why someone would pay over 3 million rupees to import, transport, tax, VAT, etc., on paper, 22 million items, which are not going to be sold in the local market? Did it occur to you at all to ask the person what was he going to do with that?
Mr. Speaker, sir, in any event, the order was placed prior to 17th of December 2015, where the company was authorized to do so. Now, coming to the question of putting on sale, I don't know if the Honourable Leader of the Opposition is aware of Regulation 4 for one of the public health restriction on tobacco product 2020. Let me finish, which provides, Mr. Speaker, sir, that no person shall manufacture, import, distribute, sell, or offer for sale in Mauritius, roll on. So it will be for the enforcement authority to ensure that these products are not meant for sale. Because when the importer, when the company requested to import these items, it made it clear that it was for personal storage.
My Mr. Speaker, I think in all my 30 years in Parliament, I have not heard such a ridiculous answer. His letter was given, his ministry's letter was given to the importer before the Ministry of Health, and thank God for once the Ministry of Health prohibited the sale in June, 3 months after his letter. Whether he was aware of what you were doing, I don't know. Now, I'm going to ask the Minister again, why someone would import 22 million cheap papiers with a so-called authorization from his ministry that he would not sell it on the local market. Why would
Mr.
someone
Speaker,
do that?
sir, I think I have been clear enough in my answer. Okay? Authorization to import was based on a law which allowed the company to import if order was placed prior to December 2015. The company did produce the purchase order, did produce evidence that order was placed prior to that date. So, yes.
All right. I have a pro forma invoice here,
Yes.
dated the same date as you say, 16th of September 2015. A pro forma invoice is a quotation, an invoice pour la forme. It is not a real order, firstly. Secondly, given that you think there was a commitment for the South African seller to supply this order was never paid for. This order was never a firm order because it was never paid for. Neither a letter of credit issued or payment made. So your ministry issued 7 years later an authorization on a spurious invoice for a spurious order which was never in fact paid for by the company. If you can produce any evidence to show that the 108,000 euros of the invoice was ever paid for by the company, then can you do so now? Because it is not a firm order.
Mr. Speaker, sir, this is a commercial dealing between the company and its supplier. Talking about the pro forma invoice, maybe the person who gave him the information did not give him the purchase order. I can produce the purchase order which was presented to the ministry for the 25,000 boxes of that particular item.
The purchase order must be accompanied by payment for it to become a firm order. Don't you agree, Minister, that you cannot just send an order and no payment made and you pretend to the ministry that it is a firm order?
How would the leader of the opposition expect me to know the dealing between the company and its supplier? What was the terms agreed between them? I would not know. Even him, he would not. He will not be in a position to know that.
I know that no payment was made ever, and this is a spurious, a false order. Now, Mr. Speaker, his ministry authorizes the importation of goods costing about 3 million rupees with a sale value on the streets of Mauritius of 460 million rupees, Mr. Speaker. Just think of that. It is more profitable probably than drugs. His ministry authorizes that and doesn't think it's necessary to refer it to the police, to refer it to ADSU, to refer it to customs. Not at all. Thinking it is absolutely normal that someone would sit on a cargo of worth 460 million rupees for his personal use. Is that what you're saying?
Mr.
Do you know the price of cheap papier?
Say that. Mr. Speaker, sir, let me answer. Mr. Speaker, sir, I understand that the police is inquiring into the matter. Okay? And to tell you frankly, Honorable Leader of the Opposition, several meetings were held between officers of the MRA, officers of my ministry, and also the representative of that particular company. And from 2017 to 2021, there have been representation made, and we did not give our consent for the company to import.
Me that over the years, this particular importer insisted to import goods of a street value of 460 million rupees, and you were persuaded that it was for his own personal use, and that he went for many years trying to persuade to you, and finally you agreed that it was for his own personal use, this 460 million rupees of goods of street value.
Speaker, sir,
that is why I understand your ministry
Mr. Speaker, sir, first of all, let's be clear. This file was never brought to my attention. It was dealt with administratively, not me. Don't point finger at me. Okay? Because I did not get involved in any decision making regarding this particular case. Now, let me 2017, Mr. Speaker, sir. So there was a meeting at my ministry. Let me look for the notes of meeting for that particular meeting, and it was decided collectively on the way forward. It was decided collectively by the ministry through the, yes, here. So, in that particular meeting, the then Deputy Permanent Secretary, 2017, I was not even there. I was appointed recently. So, chaired by the Deputy Permanent Secretary, also in attendance were officers from the Custom Department, and several issues were discussed regarding this particular case, because the issue had to be thrashed out, and it was decided the way forward. If you can listen to me carefully. The ministry, the way forward, a decision which was taken collectively by the MRA, the ministry, and the Custom Department. The ministry will request Zippy Mouse Limited to submit the contract it had with its supplier in respect of an order placed on the 16th of September 2015. That is for that 25,000 boxes you mentioned earlier. To make and quantify the remaining shipment to be imported, indicating the number of booklets with their respective numbers of leaflet per box, and a time frame as to when the whole consignment of 25,000 boxes will be imported. That was the way forward decided in 2017.
He says he was not aware, but he's defending it now.
I am not.
So, let me finish. Let me finish.
Stating the
so
facts.
he's defending it now, and he knows very well the code of ministerial responsibility, that whatever happens under his ministry is his responsibility, nobody else's. Now, I want to ask the Honourable Minister. He says there's a contract. But you're a lawyer too. Where is the contract when no payment has been made? There is no contract when no payment has been made. So there is no contract. Your ministry did not even bother. And this is where the real conspiracy is. This is a real conspiracy.
No, put your question.
Between your ministry, whoever it was there that you're saying, the importer, because he's also involved, and I will come to that, and this supplier, this importer. This is a conspiracy, and to me it appears that your ministry just whitewashed, and I'm so surprised that the minister is in fact defending. Why is he defending l'indéfendable?
I am not defending l'indéfendable, Monsieur le Président. If ever the leader of the opposition has any information regarding mal-done or malpractices or whatever thing he is trying to say, there's a police inquiry ongoing, you can go to the police. And by the way, let me inform the House, I found it surprisingly also, and I instructed, because the delay between 2017 to 2021, listen to me carefully, listen to me first, the delay between 2017 to 2071, where the ministry was constantly objecting to the issuance of a no objection. Suddenly in 2022, it gave its consent. So I instructed the Permanent Secretary of of my ministry to have a complaint made at ICAC to have an in-depth inquiry into the whole matter.
Nobody believes in ICAC anywhere on this side of the house. I'd like to ask the minister whether it did not occur to all these technicians in your ministry that the price that this person was, Zippy Mouse Limited, this Augustin was supposed to be importing in 2022. It couldn't be the same price as 7 years earlier. Who is going to give the same price for one item 7 years later? Did it not occur to you there was some conspiracy going on? You understand?
Yes.
The same price as 7 years before. Have you heard of this before?
Mr. Speaker, sir, this is for the inquiry to determine. There is a police inquiry. In any event, when the goods were seized by the striking team and the MR, an inquiry has been opened, and it will be for the inquiry to determine whether there has been any sort of thing.
The seizure is no thanks to you. It was thanks to customs based on a GN by the Ministry of Health. No thanks to your ministry, so don't take credit for that, please. I'd like to ask you whether all this time, when in 2022 your ministry decided to issue this surprising letter of importation, where it cannot be sold on the local market even though it's worth 460 million rupees. When that letter was issued, and given the amount and the risk of fraud and the problem of drug consumption, did your ministry contact the State Law Office to see that this was all in order for you to do so 7 years after an order was placed? Supposedly placed?
Mr. Speaker, sir, in June 2015, when roll on your own tobacco was delisted from the list of prohibited items, the then Deputy Prime Minister, who is the leader of the opposition, who was in the government, did not raise any objection. Then he did not raise any objection then. He could have well objected to the delisting of the said item in 2015. If he was so concerned about the rolling paper being used as for synthetic drugs or cannabis. But let me tell him that these papers are also used for roll your own tobacco, which was recently allowed by the regulations.
So you're allowing roll your own tobacco, but not roll your own paper. What a ridiculous step. How are they going to roll it in what? The papier toilet? Anyway, let me just ask the minister here whether in fact his officers, come back to the original question. The price, I have the prices here. On the final tax invoice given in 2022, compared to the quotation, the pro forma invoice of 7 years earlier, the prices are identical. I like to ask the ministry, in what, Alice in Wonderland or whatever, prices do not change for 7 years, and whether he thinks this paper, if it was produced 7 years before, and you have to, I think, lick it and stick it and all that,
you know that way?
Do you think, don't joke with me, do you think that this paper is still usable? So how is it the same price? Tell us, give us, you are defending your ministry. Tell us how it is the same price 7 years after, if you are dealing with genuine people and genuine invoices.
Mr. Speaker, sir, we have received invoice and purchase order. We go according to whatever documents that have been produced in respect of that particular item, for the importation of that particular item. You wouldn't expect the ministry to go and inquire regarding the change of price and so on.
Speaker,
And in any event, Mr. Speaker, sir, the prices are checked by the Custom Department at the time of clearance and upon delivery. It is not for the ministry to go and do all that.
Minister, that we've checked the prices and the price 3 times more than is on this invoice. So it's a shame that his people did not do it. He did not answer concerning whether he sought clearance or this murky business from the state law office. And if he did so, what was their advice?
Mr. Speaker, sir, the regulation, I think it's clear in itself. So there was no need to seek clearance. You want me to read the regulation again to you? Any layperson reading the regulation would interpret it in the same way as I mentioned earlier. So there was no need to seek guidance of the SLO on the interpretation of the regulation that were in place at that time when the order was placed.
Time
The Minister.
over. No advice. Time is over. No advice. Time is over.
1 minute left.
Time is over.
Left, Mr. Speaker.
Motion.
How can we finish?
Mr. Speaker, sir, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favor say aye, those against say no. Aye. The ayes have it. Statement.
Prime Minister.
Mr. Speaker, sir, I wish to make the following statement concerning developments in respect of the Chagos Archipelago. Following the meeting which I had with former United Kingdom Prime Minister Elizabeth Truss on 21st of September 2022 in the margins of the United Nations General Assembly, Mauritius and the United Kingdom have decided to begin negotiations on the exercise of sovereignty over the Chagos Archipelago. Through negotiations, taking into account relevant legal proceedings, it is our intention to secure an agreement on the basis of international law to resolve all outstanding issues, including those relating to the former inhabitants of the Chagos Archipelago. This will allow Mauritius and the United Kingdom, as close Commonwealth partners, to work even more closely together to tackle the regional and global security challenges that face us all. We will seek to strengthen significantly our cooperation on Indian Ocean security, maritime security and marine protection, the conservation of the environment, climate change, respect for human rights, and to tackle illegal migration, illegal fishing, drugs and arms trafficking, as well as bilateral cooperation on a range of other issues. We will work to do this in cooperation with key allies and partners in the region. Mauritius and the United Kingdom have reiterated that any agreement between our two countries will ensure the continued effective operation of the joint UK-US military base on Diego Garcia, which plays a vital role in regional and global security. We recognize the United States and India's interests and will keep them informed of progress. Mauritius and the United Kingdom have agreed to engage in constructive negotiations with a view to arriving at an agreement by early next year. I take this opportunity to express my thanks and gratitude to all states and organizations, particularly the African Union, for the support they continue to provide to Mauritius for the completion of its decolonization. Thank you. Mr. Speaker.
Next motion.
Mr. Speaker, sir, I beg understanding order 17.3 to take the time of the House for urgent business.
Seconded.
Seconded.
The question is that the Honourable Prime Minister be allowed under Standing Order 17.3 to take the time of the House for urgent business. Those in favour say aye, those against say no.
Aye.
The ayes have it.
Mr. Speaker, sir, having obtained your permission, I beg to move under Standing Order 29.1 to present a motion without notice.
Seconded.
Seconded.
The question is that the Honourable Prime Minister be allowed under Standing Order 29.1 to move a motion without notice. Those in favour say aye, those against say no.
Aye.
The ayes have it.
Mr. Speaker, sir, in the light of the incident you reported to the National Assembly on Thursday, 27th October last, regarding the words uttered by Honourable Bhagwan to your address, his grossly disorderly conduct, and the remarks uttered by the latter to the address of honourable members at the sitting of Tuesday, 18th of October last, I beg under Standing Order 49.8 to move that the honourable member be suspended from the service of the Assembly for today's and the next two sittings unless and until unreserved apologies are tendered to the House.
Seconded.
The question is that the Honourable Bhagwan be suspended from the service of the Assembly for today's and the next two sittings unless and until unreserved apologies are tendered to the House. Those in favour say aye, those against say no. Aye. The ayes have it.
Public Bill, second reading.
Mr. Speaker, sir, I move that the Dangerous Drugs Amendment Bill number 15 of 2022 be read a second time. Mr. Speaker, sir, thank you very much for allowing me to proceed with the second reading of the Dangerous Drugs Amendment Bill 2022. The main objective of this bill is to amend the Dangerous Drug Act so as to implement the recommendations of the Commission of Inquiry on Drug Trafficking Report 2018. Mr. Speaker, sir, on 14th July 2015, the President of the Republic, acting on advice of the then Prime Minister, late Sir Anirudh Jagnat, in accordance with Section 2.2 of the Commissions of Inquiry Act, appointed Pearl Lam Shang Lin, former judge of the Supreme Court, as chairperson of the Commission of Inquiry on Drug Trafficking to inquire on all aspects of drug trafficking in Mauritius. By setting up this Commission of Inquiry, late Sir Anirudh Jagnat, the father of the economic miracle, was setting the tune for the leitmotif of our Prime Minister, Honorable Pravin Kumar Jagnat, who has made it a point to honor, to carry on the fight against drug trafficking. Our zero tolerance approach towards drug traffickers has led to drug seizures amounting to 471 million rupees in 2020 and 4.7 billion rupees in 2021. Mr. Speaker, sir, the Commission of Inquiry on Drug Trafficking worked relentlessly during 3 years and released its report on the 27th July 2018. 460 recommendations were made in this document of 21 chapters and 260 pages. The national response to the drug issue is overseen and led by the High-Level Drugs and HIV Council since January 2019 and is chaired by the Prime Minister, Honorable Pravin Kumar Jagnat. Mr. Speaker, sir, to date, more than 80% of the recommendations of the Commission of Inquiry on Drug Trafficking has already been implemented or is being implemented. And today, by the amendments this government is bringing to the Dangerous Drugs Act, we are moving one step closer to a historical, bold and courageous piece of legislation driven by the determination of the Prime Minister towards a human rights approach in the treatment of people having substance use disorders to improve, treat and rehabilitation instead of criminalization. Allow me, Mr. Speaker, sir, to highlight the main provisions of this bill. To start with, in the Drug Users Administrative Panel, where a person is found in possession of drugs for his personal consumption, he will, on the recommendation of the Director of Public Prosecutions, not be prosecuted for that offense, but will instead be referred to the DUAP. The bill also makes provision for the treatment of patients with medicinal cannabis for specific therapeutic conditions where conventional treatment has not produced satisfactory results. Mr. Speaker, sir, another important feature of this bill is to empower forensic science laboratory to conduct analysis on a sample of dangerous drugs seized rather than analyzing all the dangerous drugs seized as it is the case in several other jurisdictions. In addition, the police will be given wider powers so as to enable it to detect drug offenses and will, on the order of a district magistrate, be able to destroy dangerous drugs seized rather than keeping same to be produced in court. Opportunity is also being taken to address some shortcomings in the Dangerous Drugs Act, and consequently, the Courts Act is also being amended. Mr. Speaker, sir, as stated earlier, this bill makes provision for medicinal cannabis for the treatment of patients suffering from certain conditions. This bill doesn't make provision for recreational use of cannabis. To understand the Dangerous Drugs Act, let me come to a brief definition of a drug. A drug is a medicine or other substance which has a physiological effect when ingested or otherwise introduced into the body. Medication is called drug. Heroin, cocaine are also called drugs, commonly known as illicit or narcotic drugs that have no therapeutic benefits. Dangerous drug is a category of drugs that have high tendency for abuse and dependency. Among these dangerous drugs, some have therapeutic benefits and are used under control, such that they are listed under relevant schedules of the Dangerous Drugs Act. Till now, cannabis is considered as an illicit drug, but since December 2020, the United Nations Office on Drugs and Crime, UNODC, Commission on Narcotics Drugs, took a number of decisions on the international control of cannabis and cannabis-related substances. One of the main decisions was to delete cannabis and cannabis resin from Schedule 4 of the 1961 Single Convention on Narcotic Drugs, but maintain it in Schedule 1 of the same convention for control purposes. This implied that cannabis, although highly addictive, was no longer considered to have particular dangerous properties or no therapeutic value. Mr. Speaker, sir, medicinal cannabis is a medicine that comes from the cannabis plant. Medicinal cannabis has the potential to relieve the symptoms of certain medical conditions. The cannabis plant contains cannabinoids. Two of these cannabinoids are tetrahydrocannabinol and cannabidiol. So the tetrahydrocannabinol, also known as THC, and the cannabidiol, CBD. Most medicinal cannabis products already on the market contain THC and or CBD. Medicinal cannabis is most often used for the treatment of chronic pain, epilepsy, and spasticity. It is also used for the treatment of cancer-related symptoms such as pain and nausea associated with chemotherapy. Today, more than 30 countries in the world have legalized cannabis for medicinal use. Some of these countries are UK, France, Australia, Denmark, Switzerland, Canada, Germany, Italy, United States of America, and South Africa, just to name a few. On the local front, in December 2020, government set up a technical committee on cannabis for the implementation of the recommendations of the Commission of Inquiry on drug trafficking relating particularly to the use of cannabis for medicinal purposes. The first meeting of the technical committee was chaired by the then Director General Health Services and thereafter by Professor Tishan Baoran, GOSK, Executive Director, Mauritius Research and Innovative Council. The committee comprised high officials of my ministry, the Prime Minister's office, other ministries, as well as representatives of the Police Department, the Forensic Science Laboratory, the University of Mauritius, the Mauritius Revenue Authority, the Pharmacy Council, and the Private Clinics Association. The technical committee conducted 7 meetings and closed the last meeting on the 29th of October 2021. During the sittings of the technical committee, views and comments were sought from the public on the medicinal use of cannabis through notices published in dailies. Numerous comments were received and considered by the technical committee before finalizing its recommendations. On November 26, 2021, government was apprised of the recommendations of the technical committee. The recommendations encompassed the types of cannabis to be used for medicinal purposes, authorization mechanisms, import and storage of medicinal cannabis, and also therapeutic indications. Government also approved the setting up of a steering committee under the chairmanship of the Senior Chief Executive of my ministry to look into the implementation of the recommendations of the Technical Committee on Medicinal Cannabis. The steering committee examined each of the recommendations of the Technical Committee to determine their applicability and devised ways and means for their implementation. The steering committee recommended the following among others. Only plant-derived medicinal cannabis will be used. Only importation of medicinal cannabis products would be considered in the initial stage by my ministry. A medicinal cannabis therapeutic committee to be set up at regional hospital level to assess and authorize the use of medicinal cannabis. A patient-registered system should be put in place. Medicinal cannabis products to be dispensed only in hospitals. The storage of medicinal cannabis in a government pharmacy. The definition of the formulation of medicinal cannabis to be defined by my ministry. Only authorized specialists, both public and private, would be allowed to prescribe medicinal cannabis drugs. To cater for overseas visiting patients who are on medicinal cannabis treatment, and to follow international guidelines for prescription and monitoring the use of medicinal cannabis. Mr. Speaker, sir, the introduction of medicinal cannabis in Mauritius requires an appropriate legal framework. Hence, a new Part 2A is being inserted in the Dangerous Drugs Act to deal specifically with this issue. Under Part 2A, Section 28A of the DDA, Amendment Bill number 15 of 2022, various definitions are provided for an authorized patient, an authorized specialist, and specific therapeutic conditions. It is worth noting that specific therapeutic conditions provided for in the bill have been inspired from existing international guidelines and are limited to the following medical conditions which have failed to respond to conventional treatments. First, spasticity associated with multiple sclerosis. Second, severe refractory epilepsy. Third, intractable nausea and vomiting associated with chemotherapy. And fourth, severe intractable pain. Only an authorized specialist will be allowed to issue a prescription to a patient to be treated with medicinal cannabis. As defined in Section 28A, the authorized specialist must be registered under Section 20 of the Medical Council Act and must have successfully completed a training course as approved by my ministry on the therapeutic use of medicinal cannabis and is authorized in writing by my ministry to issue a prescription to a patient to be treated with medicinal cannabis. Mr. Speaker, sir, furthermore, medicinal cannabis will be dispensed only by authorized pharmacists who must have successfully completed a training course as approved by my ministry on the therapeutic use of medicinal cannabis and who is authorized in writing by my ministry to handle and dispense medicinal cannabis. Section 28B of Part 2A of the bill stipulates that no person shall use or import medicinal cannabis unless he is authorized to do so under this part. Section 28C provides for the setting up of a medicinal therapeutic committee in every medicinal cannabis therapeutic committee in every regional hospital. As specified under subsection 2, the committee shall consist of a regional health director as chairperson, 2 government authorized specialists, and an authorized pharmacist. The committee has the power to co-opt such other person it may determine. The committee shall determine on a request made by an authorized specialist whether a patient needs treatment in medicinal cannabis. Section 28D caters for an authorized specialist shall to make a request to the medicinal cannabis therapeutic committee for a patient to be treated with this medicinal cannabis. Even an authorized specialist does not have the right to recommend that treatment prior to having referred the case to the committee of the regional hospital nearest to the residence of the patient. Furthermore, no authorized specialist shall make a request for himself to be treated with medicinal cannabis. According to Section 28F of the DDA Amendment Bill 2022, the Medicinal Cannabis Therapeutic Committee shall convey in writing its approval or rejection as the case may be to the authorized specialist. It's only when the authorized specialist gets the approval of the committee that he may prescribe medicinal cannabis treatment. Medicinal cannabis can be prescribed for a renewable period not exceeding 3 months. As you may concur, the process for a patient to have resort to medicinal cannabis as therapy has been clearly defined. To provide necessary safeguards in the dispensing of medicinal cannabis at the level of the pharmacy of regional hospitals, Section 28G provides for medicinal cannabis to be dispensed by an authorized pharmacist to the authorized patient or to a person acting on behalf of the patient as authorized by the committee. Mr. Speaker, sir, Section 28H provides for the keeping and maintaining of a register of medicinal cannabis. It will comprise of particulars of the patient, the particulars of the person acting on behalf of the patient, the name of the authorized specialist, the prescription of medicinal cannabis dispensed, and its quantity. Mr. Speaker, sir, only imported medicinal cannabis will be used in Mauritius. Section 28J provides that no person shall import medicinal cannabis unless it is imported on behalf of my ministry. Where medicinal cannabis is imported, the importer shall, under the strict supervision of the police, deliver the medicinal cannabis to my ministry. Amendments are also being brought to Section 18 of the DDA, which deals with the prescriptions of drugs. Currently, Section 18(1)A provides that, that all prescriptions need to be handwritten. This section is being amended to exempt prescriptions of methadone, which are computer-generated from being handwritten, though they still need to be hand-signed. Section 18(4)A of the Dangerous Drugs Act will be amended such that the duration of prescription of Schedule II drugs be increased from 10 to 14 days. Mr. Speaker, sir, let me now come to another amendment to the Dangerous Drugs Act, which will be a milestone in the legislative framework of the Republic of Mauritius. The setting up of the Drug Users Administrative Panel under the purview of my ministry. First of all, allow me to explain why the initial Drug Offenders Administrative Panel has been renamed Drug Users Administrative Panel. In fact, the term offender has been replaced by the term user, in as much as the term offender is used in the Dangerous Drugs Act to describe a person who has committed an offense under the Dangerous Drugs Act, including a drug dealer and a drug trafficker, to differentiate those who are in possession of drugs for personal consumption as compared with those who are in possession of drugs for dealing or trafficking. The term offenders is being replaced by users. The Drug Users Administrative Panel, DUAP, will provide the substance users with an opportunity to be taken care of in a holistic manner through education, counseling, treatment, and rehabilitation, and enable these people to be mainstream back in society. This bill provides that where a drug user is intercepted in possession of drugs, he will not de facto have to face the criminal justice system. In this connection, a new Part 3A, non-prosecution and rehabilitation of drug users, is being introduced in the Principal Act, under which, at Section 59A, the Drug Users Administrative Panel is being established. The Drug Users Administrative Panel would have as main functions and powers that of directing a drug user to undergo rehabilitation, such as education, counseling, treatment, aftercare, social integration, or any other therapy. The panel will also monitor the progress of a drug user during the period of rehabilitation. The panel shall consist of a retired judge of the Supreme Court or a barrister having not less than 15 years standing as chairperson, a barrister having not less than 10 years standing as vice chairperson, 2 retired government medical officers having knowledge and experience in the field of drug dependence, and 2 social workers having knowledge and experience in the field of drug dependence. The members of the panel shall be appointed by the Prime Minister after consultation with the Minister on such terms and conditions as he may determine. The panel shall sit in 2 divisions in order to cater for all the cases and to ensure that the process goes smoothly without delay. A division shall consist of the chairperson or vice chairperson and a retired government medical officer and a social worker selected by the chairperson. The panel may co-opt such other persons as it deems necessary. Mr. Speaker, sir, the DUAP will bring a radical change in the way we address the problem of drug use and its terrible consequences in the country. Mr. Speaker, sir, Section 59B, which provides for suspension of prosecution, is yet another crucial determinant of the proposed amendments to promote the concept of rehabilitation of drug victims. The police will carry out an inquiry to determine whether drugs were met for personal consumption, whether any aggravating circumstances exist, and whether the drug user is a drug trafficker. Based on the outcome of their inquiry, the police shall then recommend to the DPP as to whether the drug user should undergo rehabilitation instead of being prosecuted. The final decision on prosecution or rehabilitation rests with the DPP. Mr. Speaker, sir, as its title implies, Section 59C, Rehabilitation of Drug Users, makes provision for the different steps in the rehabilitation process, such as assessment of the drug user and his willingness to overcome his addiction, referral to a health institution for rehabilitation under such terms and conditions to be determined by the panel, and monitoring and reporting of progress during the rehabilitation period. The panel shall make a report to the DPP to certify the rehabilitation undergone by the drug user and whether he has complied with all terms and conditions set. It is to be noted that if the drug user fails to appear before the panel, as and when required, the panel shall refer the matter to the DPP for such prosecution or legal proceedings as he may deem appropriate. As for Section 59D, it aims at protecting the drug user insofar as any information produced before the panel. The objective is to provide ample assurance that all personal information provided will be used for the sole purpose of rehabilitation and thus encourage victims to confide themselves. Mr. Speaker, sir, with the introduction of the Drug Users Administrative Panel, DUAP, drug users will henceforth not be considered as perpetrators, but as victims of substance abuse. It is to be noted that at the 59th sessions of the Commission on Narcotic Drugs in 2016, UNODC and the WHO launched the initiative Treatment and Care of People with Drug Use Disorders in Contact with the Criminal Justice System, Alternatives to Conviction or Punishment. Thus, the recommendations of the Commission of Inquiry on Drug Trafficking for the setting up of the Drug Users Administrative Panel is totally in line with the initiative of the UNODC and the WHO. The ultimate objective of this bill is to offer the opportunity to the drug user to have a future instead of entering the judicial system and be labeled as a drug addict for the rest of his life. We are offering an alternative to the drug user, an opportunity to mend his ways so as to not to jeopardize his future. Mr. Speaker, sir, in the drafting of this piece of legislation, proposals from the Police Department Anti-Drug Smuggling Unit in connection with offences, medical examination, consignments of dangerous drugs, and safekeeping of exhibits have also been considered. Let me give some details concerning the proposed amendments to be brought to the Dangerous Drugs Act under the purview of the Police Department. A new provision at Section 39A will now provide for prosecution for conspiracy to commit drug offense. This means that any person who agrees with one or more other persons to commit an offense under the Act shall also be guilty of that offense and also be liable to the same penalty as would have been applicable to an accomplice. Provision is also being made for Section 41(1)(1) to include court premises as another place where the offense would be considered as an aggravating one. The maximum fine related to this offense has been increased from 2 million rupees to 10 million rupees. Amendments to the Principal Act will also be made at Section 42, pertaining to giving false information statements or false evidence. The minimum fine of 10,000 rupees has been increased to 100,000 rupees. The maximum fine of 100,000 rupees has also been increased and capped to 1 million rupees. The term of imprisonment has also been increased from not less than 2 years to not less than 5 years and not more than 10 years. Section 54, which covers drugs concealed in body, will also be amended. Only an officer not below the rank of Superintendent of Police will be allowed to give authorization for medical examination of a person suspected to have swallowed drugs. Furthermore, at subsection 3, an amendment will be brought to increase the fine from 100,000 rupees to 1 million rupees when a suspect refuses to submit to medical examination. At section 55, under the heading Controlled Delivery, amendments will enable a police officer to carry the consignment of dangerous drugs to be lawfully intercepted and allowed to proceed its way either intact or by replacing the drugs or part of the drugs by other substances. This proposal is due to the fact that transiting consignment containing drugs detected in Mauritius cannot actually be fully replaced by substances other than drugs prior to its passage to its recipient outside Mauritius, as foreign legislations require the consignment to consist of drugs to be amenable for an offense. Mr. Speaker, sir, the Forensic Science Laboratory has a crucial role to play in providing forensic and advisory services to law enforcement agencies. However, the inability of the FSL to conduct drug analysis and produce reports within prescribed time frame has resulted in delayed and expensive court time as per existing legislation. Proposal is being made to amend the section of the DDA dealing with conservation and sample taking of dangerous drugs. To address this issue, the FSL will align with international best practices by adopting the sampling procedures developed by the United Nations Office on Drugs and Crime, that is the UNODC. Mr. Speaker, sir, the FSL Toxicology Unit treats about 1,800 cases per year, including drug driving, workplace drug testing, drug-facilitated crimes, cannabis product analysis, and even clinical toxicology. However, FSL is using a complicated method to examine suspected prohibited drugs. Hence, Section 58 of the Dangerous Drugs Act, under the heading Conservation and Sample Taking, will be amended to allow the FSL to use a different and more productive method. The FSL will now analyze the nature, identity, and weight of dangerous drugs seized rather than the nature, composition, and content of dangerous drugs seized. The reason why this change is being brought is to reduce the time taken for sample analysis. Mr. Speaker, sir, once again, I wish to emphasize that the overarching objective of this government under the leadership of our Prime Minister is to lay the foundation for a better society where a drug user has a right to a second chance to succeed in life, even if at some point in time he happened to slip and fall prey to drugs. I wish to thank the Attorney General's Office for the huge task in the preparation of these amendments, which are being brought to the Dangerous Drugs Act. I wish to thank the Prime Minister's Office, the police, the Forensic Science Laboratory, and relevant stakeholders for their precious collaboration in the drafting of these amendments. Thank you for your attention.
You commend the bill, Minister?
I commend this bill to the House.
Seconded.
J'ai écouté attentivement, bien sûr, le ministre. Je reste sur ma faim sur un certain nombre de points que je soulèverai tout à l'heure. Ce texte de loi qui est devant nous traite de deux choses distinctes, drug use and trafficking d'une part et medical cannabis de l'autre. Je commencerai par drug use and trafficking. Depuis des années, nous autres, de ce côté de la Chambre, depuis des années, nous demandons qu'une différence soit faite entre les drogués et les trafiquants, entre les drogués malades et les criminels trafiquants. Et nous avons toujours demandé que les drogués ne soient pas envoyés en prison. Ce texte de loi va donc dans la bonne direction. Mais nous exprimons beaucoup de réserves et nous demandons beaucoup d'éclaircissements, même après ce que le ministre vient de nous dire. Et ce texte de loi va dans la bonne direction, mais ne change pas grand-chose. Et je m'expliquerai. Ce projet de loi ne change pas grand-chose. Et ce n'est pas la légalisation du gandia. Ce n'est pas la légalisation du gandia, c'est évident, mais ça vaut la peine de le souligner. Ce n'est pas la légalisation du gandia, la possession et l'usage du gandia en n'importe quelle quantité reste un délit. La légalisation du gandia, c'est ce qui se passe en Allemagne ces jours-ci, précisément. En Allemagne, donc, un texte de loi a été circulé, et devant le Parlement, que le gandia, la marijuana, for personal and recreational purposes, est légal. Un individu ou une personne peut être en possession de jusqu'à 30 grammes de gandia, peut cultiver jusqu'à 3 plants de gandia, mais la publicité est interdite et la vente du gandia ne peut se faire que dans des licensed establishments. Comme c'est le cas d'ailleurs dans beaucoup de pays, à commencer par le Portugal, mais dans beaucoup de pays de par le monde. Le but, comme l'a expliqué le ministre de la Santé de l'Allemagne, ce n'est pas d'augmenter la consommation de cannabis, mais au contraire, de mieux protéger les jeunes et de mieux protéger la santé de la population en général. Et l'Allemagne va prendre la précaution de soumettre à l'Union européenne, auquel elle appartient bien sûr, de soumettre à l'Union européenne les détails de ce que l'Allemagne propose pour obtenir son feu vert. Ce qui est proposé donc, soyons clairs, n'est pas la légalisation du gandia, de la marijuana. Et ce qui est proposé dans ce texte de loi, il faut le dire aussi, existe déjà en partie dans la loi actuelle à l'île Maurice. En effet, la section 34 du Dangerous Drugs Act prévoit que quand quelqu'un a été trouvé par la Cour coupable de posséder ou de consommer un dangerous drugs, dans le cas qui nous intéresse pour le moment, c'est le gandia, lorsque la loi prévoit donc, la section 34 du Dangerous Drugs Act prévoit que quand quelqu'un a été trouvé par la Cour coupable de possession ou d'utilisation de gandia, y compris le gandia, la Cour, si la personne concernée est d'accord, peut, au lieu de l'envoyer en prison, lui imposer such treatment, education, aftercare, rehabilitation or social reintegration as the court thinks appropriate. Mais bien sûr, dans la loi actuelle, il n'y a pas de Drug Users Administrative Panel, dont le ministre a parlé tout à l'heure, et dont je parlerai à mon tour tout à l'heure. Drug Users Administrative Panel, prévu dans la loi qui est devant nous. Et dans ce contexte, quand je fais référence à ce qui existe déjà devant la Cour, je m'empresse de dire que la question d'amender le Certificate of Character Act de 2012 pour ne pas pénaliser les jeunes et les drogués qui se retrouvent coincés, la question d'amender le Certificate of Declaration of Character Act de 2012 demeure plus que jamais d'actualité. Ce qui est proposé donc existe déjà en partie dans la loi actuelle. Ce que nous propose la loi qui est devant nous, c'est que si le commissaire de police est d'opinion, le commissaire de police, je dis bien, si le commissaire de police est d'opinion qu'un délit sous la section 34 du Dangerous Drugs Act a été commis for personal consumption par une personne qui n'est pas un trafiquant, si le commissaire de police et ses officiers arrivent à cette conclusion, alors, dans ce cas, le commissaire de police sera obligé de faire une recommandation au DPP, au Director of Public Prosecution, qu'au lieu d'être poursuivi, il suive un traitement de réhabilitation. Si le DPP est d'accord, he may, not shall. La Constitution est respectée, c'est le DPP qui décidera. Si le DPP est d'accord avec la recommandation du commissaire de police, le DPP may, not shall, advise the CP to refer the drug user to the Drug Users Administrative Panel créé à la section 59A de la loi qui est devant nous. Si le DPP ordonne au commissaire de police de référer le drogué en question au Drug Users Administrative Panel, le CPP shall obey. Le commissaire de police shall obey. Le commissaire de police est obligé de suivre ce que dit le DPP. Voilà ce que la loi prévoit. Ce qui est assez extraordinaire de la dire, et je reviendrai là-dessus tout à l'heure, donner un rôle pareil au commissaire de police et à ses officiers, c'est assez extraordinaire. C'est assez troublant. C'est assez extraordinaire. Il faut souligner ici, avant de continuer, que la loi qui est devant la Chambre ne concerne pas seulement le gandia, mais aussi, comme c'est déjà le cas pour ce qui existe concernant la Cour et la section 34 du Dangerous Drugs Act, concerne tous les dangerous drugs, y compris le synthétique. J'en arrive au rôle et aux responsabilités que la loi qui est devant nous donne au DPP et à la police. C'est assez extraordinaire. Dans le cas du DPP, I understand that le DPP, le ministre ne nous a rien dit, mais I understand that the DPP est d'accord avec cette loi. Mais je crois comprendre qu'il souhaiterait avoir le pouvoir lui-même d'envoyer un drogué directement au panel sans passer par le commissaire de police. Je suis tout à fait d'accord. Je ne suis pas sûr que tel soit le cas. Il serait bon que le ministre se renseigne, en discute au gouvernement et revienne vers nous. Dans le cas de la police et du commissaire de police, je me pose la question. Je crois qu'il nous faut nous poser la question. Dans le cas de la police et du commissaire de police, la police, le commissaire de police et ses officiers qui vont enquêter pour lui, la police, le commissaire de police, ont-ils l'expertise nécessaire pour faire ce genre de travail, pour exercer ce genre de responsabilité? Et est-ce vraiment le rôle de la police? J'ai beaucoup de doutes. La loi va dans la bonne direction, mais il y a beaucoup de dangers aussi dans cette loi-là. Il faudra s'assurer, par exemple, que les policiers qui enquêteront et qui recommanderont que tel ou tel drogué soit référé au panel et un autre et d'autres seront traduits en cours. Il faudra s'assurer que ces policiers-là soient honnêtes, apolitiques et qualifiés. Ce qui se passe, par exemple, dans le cas des décisions, mes amis avocats, les honorables avocats, le savent mieux que moi. Ce qui se passe, par exemple, dans le cas des décisions de la police d'objecter ou non à des demandes de bail, de caution, devrait nous éclairer. Et c'est aussi ce qui me fait me poser la question si c'est vraiment le rôle de la police d'exercer ce genre de responsabilité-là. Le danger de la corruption et de la politisation sera très grand. Et nous savons déjà quels dégâts la corruption et la politisation à outrance, quels dégâts cela fait dans notre pays. Dans le cas du Drug Users Administrative Panel, sa composition a été lourdement critiquée dans la presse ces derniers jours. Et la proposition qu'il siège en 2 divisions, malgré ce que le ministre a dit tout à l'heure, n'a pas été bien expliquée, bien détaillée. Par ailleurs, la loi prévoit que les drogués concernés soient rehabilitated, je cite, at a public health institution or such other institution as the ministry may approve. Je souhaiterais que le ministre nous donne un peu d'indication, à part les public health institutions, quel genre d'institutions le gouvernement, le ministère a en tête, such other institutions as the ministry may approve. Et une fois approuvé, quel genre d'aménagement il faudra faire dans ces institutions autres que des public health institutions, quels amendements il faudra faire pour accueillir les drogués concernés. De plus, la loi parle aussi, et le ministre en a parlé, de the person in charge of such institutions. Pas les personnes in charge des public health institutions, mais such other institutions, à part les public health institutions, la loi nous dit que the person in charge of such institutions, ces genres de responsables auront de lourdes responsabilités. Il faudra donc s'assurer qu'ils soient pleinement qualifiés. Enfin, le risque de saturation, puisque le nombre de drogués à être traités dans des public health institutions ou such other institutions as the ministry will nominate, le nombre de drogués à être traités va nécessairement augmenter, et probablement beaucoup augmenter. Et c'est pourquoi, dans la presse ces derniers jours, le risque d'une saturation des centres où seront réhabilités les drogués a été souligné. C'est un risque réel, c'est évident. Et des mesures auront donc à être prises pour éviter cela. Voilà ce que j'avais à dire sur drug use and trafficking. Il faut être sans pitié pour les trafiquants, sans pitié pour les criminels, mais il faut faire tout ce qu'on peut pour aider les drogués, aider les malades. Et je le répète, ce texte-loi va dans la bonne direction, mais ne change pas, n'ajoute pas grand-chose. Je terminerai par quelques mots seulement, puisque le ministre s'est étendu longuement sur la question du cannabis médical. Je dirais seulement mieux vaut tard que jamais. Mieux vaut tard que jamais, mais il est bien sûr indispensable de prendre toutes les précautions nécessaires concernant l'importation et l'utilisation du cannabis médical. Mais il ne faut pas non plus rendre l'utilisation du cannabis médical excessivement difficile et laborieux. I have done. Thank you.
Thank you, Mr. Speaker, sir. With your permission, I would like to begin my intervention with the following quote. The population overwhelmingly and very clearly express its faith and trust in my government to bring meaningful change to the daily life of our people and to lead them towards happiness, prosperity, and a better future. To this end, my government made a pledge to the population to combat drug consumption and drug trafficking. As a caring government, we could not remain indifferent to the thousand men and women who have been suffering from this scourge. Compassion is crucial in this fight, and my government remains sensitive to families, especially young people who have their careers and lives compromised. End of quote. Mr. Speaker, sir, these are the very words of our Prime Minister, and the reason I have chosen to start with this quote is to remind the House and remind the population, as well as to reiterate the vision of the Prime Minister and his government in combating drug consumption and trafficking. Mr. Speaker, sir, we are all aware of the effect of drug trafficking on the economy of any country. Governments pay the high price through lost productivity, mainly due to lower labor output, incarceration, premature death, healthcare costs that are associated with treatment, and other drug-related medical consequences. Mr. Speaker, sir, we should note that while only a handful enrich themselves, a large majority falls victim to drug dealers by becoming users, consumers, and they spiral into this more of social exclusion and, unfortunately, very often into death. Mr. Speaker, sir, our war against drug consumption and drug trafficking requires a firm commitment. The critical part and the driving force behind this commitment is the political will to undertake this war in the first place. The effort made in the recent years by this government under the leadership of our Prime Minister is evidence enough of our strong determination to engage in this fight. The population will recall on how many times had a commission of inquiry insistently been requested to combat this scourge, and most importantly, the population will also recall how many such inquiries have there been in the past. 2 commission of inquiries, Mr. Speaker, sir, have been set up, one in 1987 by late Sani Jagnat and one in 2015 by Honorable Praveen Kumar Jagnat. I can only commend the latter's laudable determination for perpetuating this noble mission, and this is why today, in this August Assembly, I have to pay tribute to both late Sani Jagnat and the current Prime Minister, Honorable Praveen Kumar Jagnat, for their unshakable political commitment to the fight against drugs. The elaboration of a National Drug Control Master Plan 2019-2023 for a safer and healthier Republic of Mauritius and the introduction today of the Dangerous Drugs Amendment Bill of 2022 are just 2 sides of the same coin. One aims at combating drug proliferation and consumption, while the other provides for rehabilitation to those who, as consumers, got tangled into hard drugs and its consumption. Mr. Speaker, sir, in order to respond to and to overcome this scourge, this bill places a lot of emphasis on rehabilitation of drug users, and with your permission, Mr. Speaker, sir, I shall focus my intervention on this part. A new Part 3A will be inserted in the Principal Act. The Drug Users Administrative Panel, as mentioned by the Honourable Minister earlier, will be set up to that effect, so that when a person is suspected of having committed a drug offence for his own use, the Commissioner of Police may suggest to the Director of Public Prosecution that the presumed drug user be considered for rehabilitation. He will not be prosecuted for this offence, but be brought before the DUAP and benefit from education, counselling, treatment, monitoring, social reintegration and other therapies. Mr. Speaker, sir, Honourable Paul Béranger, who spoke before me, mentioned about the capacity of our police to carry out such responsibilities, and at some point I think he did question the impartiality of the police. Mr. Speaker, sir, I believe it is not very proper to have value judgment on the integrity itself of our police department, and we have to make sure that we understand that this articulation between the Office of the Commissioner of Police and the Office of the Director of Public Prosecution actually is providing for a better safeguard to the consumer, the citizen, Mr. Speaker, sir. Like laid out by the mover of the bill, the panel will track the client's development and assist him in kicking his drug addiction. The bill, Mr. Speaker, sir, focuses on the rehabilitation of drug users, and I'm sure all members in this House and the population will agree on its importance. Mr. Speaker, sir, drug dealers use different channels to enhance their drug trade and focus on diversifying their product range and their market targets. It is being observed that cheaper and deadlier drugs are being offered to our young citizens, We have witnessed that drug users will stop at nothing to obtain their daily fix, going to the extent of harming their own beloved ones, their own near and dear, stealing savings, looking for more and more money for the consumption of drugs, because as time goes by and the frequency and the potency of the drug being consumed increases, it is therefore undeniable that rehabilitation at an earlier stage of consumption is of primary importance. Mr. Speaker, sir, we are witnessing not only a rejuvenation among drug users, but unfortunately a degree of feminization of this social ill. As the Minister in charge of Family, Women and Child Welfare, I have on countless occasions urged for more collaboration and responsibility. But, Mr. Speaker, sir, one has to remember that parental responsibility does not only limit itself to caring for a child after one has given birth to a child, it also includes being responsible from the time of conception as well. It is distressing to note the number of cases of innocent newborn paying the price of drug-using parents. And once again, the provision of this bill will give the chance to such parents, to, in particular, expectant mothers, to become drug-free. Mr. Speaker, sir, the adverse impact of illicit cultivation, trafficking, production, and abuse of drugs on the island is profound, and the Prime Minister and his government has never ignored the gravity of the matter. This government has been relentless in its fight against drug trafficking, and I dare say we have tangible results. The results being a collective one and not just the government's achievement. And this, when I say this, it begs the question, Mr. Speaker, sir. This is a commendable fight, albeit being a very, very difficult one, but it begs the question whether we are all on the same level, on the same wavelength when it comes to this fight against drugs. Recently, the population will recall in one particular raid carried out by the police when a person was apprehended with la main dans le sac ou le sac dans la main. Mr. Speaker, sir, here is the, well, there you go, that's the reaction I refer to. There are some who are really as uncomfortable with this situation, and I reassure the House, Mr. Speaker, sir, and the population as well, that nothing and nobody will deter this government in the war against drugs. Mr. Speaker, sir, while harsh punishment is provided for drug trafficking, and while we must show zero tolerance to drug dealers, and here we are on the same wavelength, Honourable Béranger and myself, zero tolerance to drug dealers, we must have empathy for the victims of drug usage. This is unfortunately a global rejuvenation of drug victims. We have a choice. We do have a choice. Either we do nothing, or we provide special consideration to those victims through rehabilitation programs in order to help them overcome this challenging position and provide them with a chance for a better life. And this bill, Mr. Speaker, sir, is doing exactly that. The drug issue is like a chasm, Mr. Speaker, sir. It is not one that can be crossed with small baby steps. We have to take a giant leap and leave no stone unturned when it comes to the lives of our children, our youth, and our families. We have not remained silent to the desperate call of so many parents. The unprecedented recent seizure of drugs in our country means that this very drug is not going to be entering mainstream circulation, and therefore will not be reaching our youth. And as Minister responsible for child and family and women well-being, and also as a mother, I welcome this bill wholeheartedly. Mr. Speaker, sir, I wish to once again stress that it is not a war only for the government, it is a war to be fought at every level of our society by all stakeholders concerned. It is a societal problem that cannot be resolved without the commitment of each and every one, government, civil society, community-based organization, professional, in fact, every citizen, Mr. Speaker, sir. This bill is a vivid testimony of this very commitment. There is no room for political agendas in this endeavor, and I dare hope that there will be nobody who is going to be using this platform for debate surrounding this bill for any political antics, because this is a bill that calls for a united stand, and that is against drug altogether. This bill shows the determination of the government to look at drug users in a different way, by treating them as patients and rehabilitating them instead of looking at them as offenders. It is inherent, it is in this government's DNA to combat this scourge, and I acknowledge that the journey will be a long one, most likely peppered with hurdles, some laid by known and some laid by unknown enemies, but I have no doubt that the conclusion of this war will be a foregone conclusion, and it will be only victory. We know that our population will support us for the welfare of our children and our communities. Mr. Speaker, sir, to conclude, I cannot commend enough this government, I cannot commend enough the Honourable Prime Minister, and in this particular case, I cannot commend enough my colleague Honourable Dr. Jagat Pal to have come up and brought this bill to the House. I thank you all for your attention. Long live the Republic of Mauritius. Thank you.
At this stage, we suspend the sitting for half an hour.